Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 fiancé visas. We're specifically discussing them in the context of those Americans who have a Khmer fiancé whom they are processing a case with through the U.S. Embassy in Phnom Penh, Cambodia. We have other videos on this channel which specifically discuss the new public charge rule in a more broad and generalized context. This video specifically is discussing it for those who are bringing a Cambodian fiancé over from Cambodia, processing through the embassy in Cambodia, then coming to the United States, filing for adjustment of status to green card status. So for now, this new public charge rule, the brunt of this is not going to be hitting the applicant necessarily while abroad in K-1 status, because K-1s are kind of an odd duck in the sense that they're not exactly immigrant visas, but they're not non-immigrant visas in the traditional sense. They're basically a dual intent visa, if you will, insofar as the applicant, can kind of have this dual intent of, I may go back or I may go to the United States and live there indefinitely. I'm going over there in order to meet my fiancée and presumptively marry in the United States. There has to be an intention to get married. There has to be an intention to immigrate. But, if that doesn't happen, so long as that person leaves the United States, it's sort of a no harm, no foul. So it is a non-immigrant visa, but in many ways it's treated as an immigrant visa, and in many ways it's treated as a non-immigrant visa. So it's kind of in there in the middle. That being stated, one of the main things that has changed with respect to the analysis of the public charge rule is it has, first of all, it's created a lot of discretion with respect to the adjudicating officer. They have to determine if in their mind they believe this person will in the future become a drain on state resources, basically. Start going on means-tested benefits, aka welfare, things like SNAP, TANF, various Section 8 housing things, Medicaid, these kinds of things. In the past, this sort of discretionary, do you believe this person could prospectively go on those benefits, that really didn't exist in the analysis previously. Now it does. The other thing that did not exist before was the heightened threshold when it came to issues associated with income and assets. You basically have to, the American sponsor has to show they can support their fiancé, cum spouse in the United States, and they need to show that they have enough income and assets in order to do so, or I should say income and or assets to do so in order to provide support. In the past, it was a lower threshold. That threshold has been raised. Now, each case, the given facts of that case is, they're all going to be different, so I'm not going to get into specifics of how this is all going to work. Not a terrible idea to contact a competent legal professional who's well-versed in immigration matters, because the public charge rule, notwithstanding the fact that, again, the public charge rule, K-1 fiancés are not going to bear the brunt of this necessarily during the process of getting a K-1 visa. But on the back end, in dealing with the adjustment of status, for example, the I-944 form, which is the Declaration of Self-Sufficiency form, these kind of documents are going to be rather onerous. And during the adjustment process, I think we're going to, this is going to get a lot harder than it was in the past. Again, seeking professional legal advice is probably a good idea for those who are having issues with this.